Hi, everybody. And today we will look at the issue related to the enlargement of the Union, a rather hot topic, especially after the outbreak of the Russia-Ukraine war, due to the possible accession of Ukraine and consequently the revival of a whole series of applicant countries whose requests have remained unanswered. I repeat, even today, even in this lesson, that I'm very sorry, but I'm a little bit sick. So I'm sorry for my voice, but I hope that everything will be clear. So let's go. First of all, we need to briefly make some legal references regarding the possibility of enlargement. What is EU enlargement? Enlargement is the process that allows states to join the European Union once they have met a series of political and economic conditions. An European state that respects the EU's democratic values and commits to promoting them may apply for EU membership. So, the accession criteria, or better called um, Copenhagen criteria, named after the European Council meeting in Copenhagen in 1993 that defined them, are the essential conditions that all candidate countries must meet in order to become EU member states. And these criteria are political criteria. That means stable institutions guaranteeing democracy, the rule of law, human rights, and the respect and protection of minorities. Economic criteria, that means a functioning market economy and the ability to cope with the competition and market forces. The administrative and institutional capacity to effectively implement the EU acquis, the body of common rights and obligations, and to take on the obligations of EU membership. So the EU ability to absorb new members while maintaining the momentum of European integration is also an important consideration, but we will see it during this lesson. So once a state has applied for EU membership and its application has been accepted by all EU member states, the accession process can begin. The opening of formal accession negotiations requires the agreement of all EU member states. And these negotiations help prepare the candidate for the future membership and focus on adopting the consolidated EU law acquis mm, and implementing the necessary reforms in the judicial, administrative, and economic fields. When negotiations on all policy areas are concluded and the EU itself is ready for enlargement in terms of absorption capacity, the terms and conditions of accession, including any safeguard clauses and transitional provisions, are set out in an accession treaty. This treaty must be approved by the European Parliament and unanimously by the Council before being signed by all EU member states and the candidate country. Once all contracting parties have ratified the accession treaty in accordance with their respective constitutional requirements, the candidate becomes an EU member state on the date established in the treaty. So the process of joining the EU accession broadly consists of three stages. When a country is ready, it becomes an official candidate for membership. But this does not necessarily mean that formal negotiations have been opened. The candidate then moves on to formal membership negotiations. a process that involves the adoption of established EU law, preparations to be in a position to properly apply and enforce it, and implementation of judicial, administrative, economic, and other reforms necessary for the country to meet the conditions for joining, known as accession criteria, the one that I mentioned. And third, when the negotiations and accompanying reforms have been completed to the satisfaction of both sides, the country can join the EU. So, what is membership negotiations in detail? Membership negotiations cannot start until all EU governments agree in the form of a unanimous decision by the EU Council on a framework or mandate for negotiations with the candidate country. Negotiations take place between ministers and ambassadors of the EU governments and the candidate country in what is called an intergovernmental conference. So, negotiations under each chapter are based on the following elements. The screening means the Commission carries out a detailed examination together with a candidate country of each policy field, called chapter, to determine how well the country is prepared. The findings by chapter are presented by the Commission to the member states in the form of a screening report. The conclusion of this report is a recommendation of the Commission to either open negotiations directly or to require that certain conditions, so-called opening benchmarks, should first be met. Then, negotiating positions. Before negotiations can start, the candidate country must submit its position and the EU must adopt a common position. For most chapters, the EU will set closing benchmarks in this position, which need to be met by the candidate country before negotiations in the policy field concerned can be closed. For Chapter 23 and 24, the Commission is proposing that in the future these chapters would be opened on the basis of action plans, with interim benchmarks to be met based on their implementation before closing benchmarks are set. So the pace of the negotiations then depends on the speed of reform and alignment with EU laws in each country, and the duration of negotiations can vary, starting at the same time as another country is no guarantee of finishing at the same time. Then we have the concluding the negotiations. Um, And first of all, we have closing the chapters. So, no negotiations on any individual chapter are closed until every EU government is satisfied with the candidate's progress in that policy field, as analyzed by the Commission. And the whole negotiation process is only concluded definitively once every chapter has been closed. Then we have the accession treaty. This is the document that cements the country's membership of the EU, and it contains the detailed terms and conditions of membership, all transitional arrangement and deadlines, as well as details of financial arrangements and any safeguard clauses. So it is not final and binding until it wins the support of the EU Council, the Commission, and the European Parliament, is signed by the candidate country and representatives of all existing EU countries, is ratified by the candidate country and every individual EU country according to their constitutional rules, so parliamentary vote or referendum, etc. And then we have acceding country. Once the treaty is signed, however, the candidate becomes an acceding country. This means it is expected to become a full EU member on the date laid down in the treaty, providing the treaty has been ratified. So, in the interim, it benefits from special arrangements, such as being able to comment on drafts EU proposals, communications, recommendations, or initiatives, and an active observer status on EU bodies and agencies. So, it is entitled to speak, but not to vote. So, the EU's relations with the Western Balkan countries take place within a special framework known as the Stabilization and Association Process. It has three aims: stabilizing the countries politically and encouraging their swift transition to a market economy, promoting regional cooperation and eventual membership of the EU. A country is offered the prospect of membership, so it becomes a potential candidate, and this means it should be offered official candidate status when it is ready. So the process helps um, the countries concerned build their capacity to adopt and implement EU law, as well as European and international standards. It is based on an ever closer partnership, with the EU offering a mixture of trade concessions, duty-free access to EU markets, economic and financial assistance, assistance for reconstruction, development, and stabilization and association agreements, a far-reaching contractual relationship with the EU, entailing mutual rights and obligations. So each country moves step by step towards EU membership as it fulfills its commitments in the stabilizations and association process, and the Commission assesses progress made in annual progress reports published each autumn. Well, which is the role of the Council in this field? The Council, in its general affairs configuration, oversees the EU enlargement process and accession negotiations, which are intergovernmental by nature. With regard to issues related to enlargement policy, the Council generally acts through unanimous agreement among all EU member states. Each year, the Council adopts conclusions on enlargement, taking stock of the progress made by each of the candidate countries and EU partners on their path towards EU membership. The latest enlargement conclusions were adopted on the 17th of December 2024. And in these conclusions, the Council reaffirmed its commitment to enlargement, in line with the renewed consensus on enlargement approved by the European Council in December 2006, the subsequent Council and European Council conclusions, as well as the EU's strategic agenda for the period 2024 to 2029. Well, let's see a little bit of history of the EU enlargement process. After decades of standstill, Russia's tragic aggression against Ukraine has revitalized the debate on the enlargement of the European Union within European institutions. The EU currently counts 27 states, and since the 1st of July of 2013, the date of Croatia's accession, the enlargement process has seen little substantial progress. So, Let's retrace this long path and analyze the recent developments. For some, the enlargement of the Union is both natural and inevitable as it promotes the values enshrined in the treaties. This international organization has a European vocation across the entire continent, and enlargement allows it to promote its values by creating stability in the states included. So the main benefits include the promotion of the stability, because candidate countries must undertake specific social and economic reforms in order to join, thereby strengthening the rule of law, democracy, and respect for human rights. The economic growth, because enlargement fosters the free movement of goods, of services, capital, and people, stimulating economic development. A greater political weight, because a larger European Union becomes more influential on the international stage. And last, integration and overcoming historical divisions. The accession of Eastern European countries, in particular, has helped to overcome the ideological divides of the Cold War, promoting greater stability and cooperation. So, um, on the other hand, there are opposing voices, mainly of a political nature. For example, the number of members of the European Parliament from each member state is proportional to its population. Therefore, if Turkey were to join the European Union, it would become one of the most influential countries in political decision making. Are Europeans and European institutions ready for such a prospect? At the same time, candidate countries also benefit from accession, integration into the European market, and the harmonization of their economic and administrative system with those of the EU stimulate their economic growth. The rapid economic progress seen in Eastern European states is clear evidence. Enlargement helped them overcome the ideological divide of the Cold War, as I said, and represented a major step forward towards stability on the continent. So, let's see a little bit of history of EU enlargement, starting from the 70s and 80s. The founding countries of the European uh, Union's predecessor organizations were only six: Belgium, France, Italy, Germany, Luxembourg, and the Netherlands. While today the Union has 27 members. Over the course of its history, the EU has gone through seven rounds of enlargement. The first enlargement was in 70s and 80s and took place in 1970s when Denmark, Ireland, and the United Kingdom joined the EEC, raising the number of member states to nine. I'm sorry. In the 1980s, the number increased to 12 following the accession of Greece in 1981 and Spain and Portugal in 1986. Then, in 1995, 2 years after the signing of the Maastricht Treaty, Austria, Finland, and Sweden became part of the newly established European Union. On the 1st of May 2004, we had a historic date for the European Union, as nine countries such as Cyprus, Estonia, Latvia, Lithuania, Malta, Poland, the Czech Republic, Slovakia, Slovenia, and Hungary joined, and this was joined the European Union, and this was the largest enlargement in terms of population and number of countries. And Romania and Bulgaria followed in 2007 and Croatia in 2013. However, everybody knows that the United Kingdom became the first country to leave the European Union, reducing the number of member states to 27 with its withdrawal. But let's go to the countries currently candidates for EU membership. It is difficult to predict the future of European enlargement policy since various interests are at stake and the process has become a victim of its own rules. Because unanimity is required in decision making, the higher the number of member states, the harder is to reach agreement. So yet another enlargement of the EU is possible as 10 aspiring countries are currently engaged in the accession process. So the official candidate countries are Albania, Bosnia and Herzegovina, Georgia, Moldova, Montenegro, North Macedonia, Serbia, Turkey, and Ukraine. And we have also country awaiting the candidate status, like Kosovo, who has submitted its application for EU membership, but has not yet been granted the candidate status. So their path towards accession is nevertheless tortuous, as many international observers confirm, since these states still fail to meet the institutional, economic, and administrative requirements necessary to become union members. The case of Turkey. Turkey, for instance, opened the accession negotiations in 2005, but has recently backtracked on judicial independence and freedom of expression. The EU enlargement policy became a matter of debate when Ukraine and Moldova were granted candidate status in June 2022, followed by Bosnia and Herzegovina in December 2022 and Georgia in December 2023. And also some curiosities about EU enlargement. In the past, Morocco, Switzerland, Norway, and Iceland applied for EU membership. Morocco has on several occasions expressed its willingness to join the European Union, but its application was rejected because it is not considered a European state and does not meet the economic and political criteria, particularly given the territorial dispute in Western Sahara. As for the other states, their application were blocked by popular will, which preferred less institutionalized form of trade cooperation. Well, diversity and cultural pluralism are valuable allies of democracy. The European Union has also benefited from them through its enlargements. Similarly, EDUXO, with its Youth Power EU campaign, seeks to promote intergenerational pluralism within European institutions. Each member state adopts its own electoral rules, setting the minimum age for voting and for being elected to the European Parliament, which directly affects representativeness in that country. And for instance, under Italian law, we have the minimum age for standing as candidate is relatively high, preventing younger people from having their voices represented. For this reason, Eduxo advocates for lowering this threshold, believing that decision-making processes would become more representative and inclusive. And let's go now towards a key issue. With this procedural and geopolitical overview in mind, um, I would now would like to focus on a problem that cuts across the enlargement process. That is the respect for the rule of law. But let's see some preliminary considerations on the role of the rule of law in the enlargement process, because the principle of the rule of law in the EU, thanks to the case law of the Court of Justice, now conditions the legal evolution of broad sectors of European integrations. Its substantive and operational value, which includes fundamental rights, even in cases of systemic violations, makes it much more than a symbolic principle, contrary to a superficial reading of Article 2 of the treaty. One area in which it is gaining increasing importance in the EU enlargement process concerning the Western Balkans and the Eastern Partnership countries, I mean Ukraine, Moldova, and Georgia. And the Commission's 2020 communication defined it as a central benchmark for assessing the progress of candidate countries, recognizing its decisive role in democratic transformation. So it is therefore necessary to verify whether the caution that today characterizes enlargement depends not only on difficulties linked to the fragmentation of the Union, but also on the growing relevance of the rule of law. This implies a rethinking the Copenhagen criteria, no longer merely placed within the political criterion alongside democracy and human rights. The rule of law now appears to cut across the economic and legal criteria as well as the so-called fourth criterion, namely the EU's capacity to absorb new states without compromising cohesion and functioning. So, according to the Commission, absorption capacity is the ability to integrate new members without undermining the objectives of the treaties, taking into account institutional impact and need for reforms to make the decision-making process more effective. From this perspective, the rule of law is relevant for the functioning of administrative and judicial structures, becoming an essential component of the fourth criterion. And its notion as an ex post parameter of absorption capacity does not differ from that which states commit ex ante to respect at the time of the membership application. So the principle of the rule of law has assumed an autonomous meaning in the EU law, distinct from both the national legal system and international law, as well as from the values such as democracy, gaining greater clarity in the pre-accession screening phase. Its function varies depending on the context. In the internal dimension of integration, it operates as a criterion of absorption and ex post conditionality, while in the external dimension of enlargement, it is linked to the three Copenhagen criteria that I mentioned and to the intergovernmental nature of negotiation procedures. So, this duality highlights the so-called Copenhagen dilemma. The EU is effective in assessing the accession of a new state, but struggles to guarantee compliance with the values once it becomes a member, as shown by the cases of Poland and Hungary. Internal violation of the rule of law are constitutional and systemic in nature, affecting mutual trust which is the basis of judicial cooperation and mutual recognition in civil and criminal matters. So, mutual trust founded on respect for the rule of law that becomes central to the EU's absorption capacity and requires a reinterpretation of the fourth criterion, not only in functional terms, but also as a limit on the integration of new states. And this limit is represented by the resilience of the near absolute presumption that states respect the values of Article 2 of the treaty, even in the face of rule of law backsliding. Sorry. So the accession procedure requires a complex process of institutional, legislative, and administrative reforms in order to meet Copenhagen criteria. And these include stable institutions, democracy, the rule of law, human rights, the protection of minorities. So the rule of law placed among the political criteria is subject to particular scrutiny alongside the democracy and human rights. And in addition to the political criterion, the candidate country must have a functioning market economy, following the economic criterion, and the ability to assume the obligation deriving from membership, including the acquis communautaire, um, legal or functional criterion. However, in the light of the pervasive nature of the rule of law, this division today appears a little bit schematic. And recent case of the Court of Justice shows that the rule of law operates across all Copenhagen criteria. In its judgment of the 16th of February 2022, rejecting the actions brought by Hungary and Poland against the regulation number 2092 of the 2020, the so-called conditionality regulation, the court reaffirmed that respect for the values of Article 2 is a precondition for enjoining the rights deriving from the treaties. So, membership of the rule of law of the EU is based on these values, which constitute essential and autonomous characteristics of the European Union and also of the Union law. And the principle of the rule of law thus conditions the application of each criterion. On the economic level, for instance, Regulation 2092 that I mentioned, the so-called conditionality regulation, provides that violations of the rule of law are relevant when they compromise or risk compromising the sound financial management of the EU budget or its financial interests. So the court has also recognized that compliance with the rule of law may serve as basis for conditionality, a conditionality mechanism falling within the financial rules under Article 322 of the Treaty of Functioning. And finally, the SPED Pro versus Commission judgment highlighted the impact of systemic deficiencies in the rule of law on competition law and on relations between the Commission, national authorities, and national courts, even going so far as to annul a Commission decision precisely because it had failed to take them into account. So the independence of the judiciary and expression of the rule of law ensures the protection of fundamental rights, even in antitrust proceedings. And case law emphasizes the transversal nature of the rule of law, which underpins mutual trust among member states and supports mutual recognition and loyal cooperation, not only in the area of freedom, security, and justice, but also in the relations between the Commission, national competition authorities, and national courts in the application of Article 101 and 102 of the Treaty of Functioning. So the distinction between the economic criterion and acquis communautaire loses meaning in the judgment of the 18th of May 2021. Um, it's a Romanian applicant, where the court reiterated that both the internal market and the area of freedom, security, and justice rest on mutual trust in the respect for the rule of law by all member states. So this logic was already present in the Commission decision number 928 of the 2006, which closely linked the rule of law, the internal market, and the area of freedom, security, and justice, making the certainty of compliance with the rule of law their common foundation. So, the definition of the principle as a transversal criterion has had two main consequences for candidate countries. First, the rule of law has acquired autonomy from the notion of democracy, becoming a distinct benchmark. And new chapters of the acquis have been introduced, increasing from 31 to 35, including chapter 23, that concerns the judiciary and fundamental rights, and chapter 24, that concerns justice, freedom, and security. These innovations, which emerged after the fifth enlargement, made pre-accession screening stricter than it had been for Central and Eastern European countries, where checks had been limited to respect for the separation of powers. And from a methodological standpoint, chapters 23 and 24 have become central to the pre-accession strategy. They are open first, remain open throughout the negotiations, and can only be closed at the very end once the required conditions are fully met. So the Council, the European Council, and the Commission, with the communication announcing the accession process, um, approved a new methodology for enlargement. It provides for greater control by member states and allows, in case of serious and prolonged stagnation or backsliding, for the suspension of negotiations, the reopening of already closing chapters, the reduction of funding, and the limitation of benefits such as access to the internal market. In essence, so every stage of the negotiations can be frozen or made reversible if the progress is deemed insufficient. And this methodology, which makes the outcome of accession uncertain, now characterizes the negotiations with the Western Balkans and explains the greater caution compared to the fifth enlargement. Uh, an example, the case of Montenegro is emblematic. In its 2020 communication, the Commission noted limited progress on the judiciary and fundamental rights, chapter 23, and on justice, freedom, and security as chapter 24. Although Montenegro had opened the last chapter of negotiations, the Commission reiterated that the key benchmark remains compliance with the rule of law parameters set out in chapters 23 and 24, regardless of progress in other chapters. So Montenegro will be will only be able to advance if it addresses shortcomings regarding freedom of expression and of the media, the fight against corruption, and judicial independence. This assessment was confirmed again in the 2021 communication. And the new approach recognizes that the rule of law as the ultimate condition and limit for the closing of negotiations, making the Western Balkans accession timelines longer than those of the fifth enlargement. So the accession criteria are, we can say that are dynamic in nature and may expand throughout the different stages of integration. Article 49 of the treaty refers to the criteria defined by the European Council, thereby also including those subsequent to Copenhagen. And the recognition of the rule of law as an essential element, not only of the political criteria, but also of the economic and legal criteria, laid the groundwork for further benchmarks and more intrusive monitoring of candidate countries. And the fourth criterion relating to the EU's capacity of absorption to absorb new members is particular because it concerns not the candidate state, but the union itself. And thus it could happen that a country fulfills the three Copenhagen criteria, but still cannot join if the EU is not able to bear the enlargement. So this criterion had already been taken into account in negotiations with Turkey and in the accession of Spain, Portugal, and Greece, influencing the timing of entry for regimes emerging from dictatorships. And it also underpins the cooperation and verification mechanism for Bulgaria and Romania and the safeguard clauses in Article 37 and 38 of accession, which allows the Commission to suspend cooperation instruments in cases of serious shortcomings in the implementation of EU law, especially regarding the civil and criminal mutual recognition. So these clauses never applied reflect the need to ensure a high standard of rule of law protection and to preserve absorption capacity, particularly for states facing delays in justice reform, the fight against corruption and organized crime. And the indeterminacy of the concept of the rule of law risks a discretionary use, however, by member states, which could invoke it to block enlargement to countries they disfavor, even if such countries comply with the Copenhagen criteria. And it is therefore necessary to better define its content, going beyond the Commission's generic 2006 reference, thereby inevitably raising the bar for new accession. Well, a contribution in this direction came from the principle of non-regression set out by the Court of Justice in the Republica Malta case. The judges held that a member state cannot introduce reforms, even constitutional ones, that reduce the protection of the rule of law and judicial independence, that are values enshrined in Article 19 of the treaty. So states, therefore, cannot adopt rules in conflict with the values accepted at the time of accession. And this clause was reinforced by judgment of 2022, which dismissed the action of the Hungary and Poland against the regulation, the conditionality regulation. And here the court clarified that compliance with the values of Article 2 of the treaty is a condition for enjoying the rights deriving from the treaties, that is a continuous obligation not limited to the pre-accession phase alone. So mutual trust among member states is indeed founded um, on a permanent commitment to respect these values. And the continuous nature of this obligation is reaffirmed even while respecting national identities, since states share a common notion of the rule of law rooted in their constitutional traditions. And in this way, the court avoids a static interpretation that would freeze the standard of protection at the time of accession, even when it dates back decades, ensuring instead a dynamic model of integration. The clarification allows the rule of law to be read in a dynamic perspective, as the protection of values in constant evolution that must be guaranteed even after accession, adapting to the meaning that I take on in different phases of integration. It is interesting also to note that in the Italian version of the Copenhagen criteria, the term rule of law does not appear, but rather principio di legalità, that is the principle of legality. So the choice reflects the formal conception then prevailing, conceding with the principle of legality as affirmed in Lever judgment. And um, this shows the need to interpret the criteria in an evolutionary sense from a formal conception to a substantive one, thanks to the inclusion of fundamental rights within the rule of law recognized both by the case law of the Court of Justice and by the EU institutional documents. So read through the prism of the values of Article 2, uh, absorption capacity today includes the rule of law as an essential element of the fourth criterion to be seriously evaluated in the requirements of candidate countries. And this is crucial because respect for the rule of law underpins cooperation mechanism based on mutual trust, and the EU's ability to maintain the near absolute presumption that states respect the rule of law, even with the new entrants, represents the measure of its absorption capacity. So avoiding the accession of non-compliant states therefore serves to protect the presumption underpinning instruments such as mutual recognition. And in particular, since the court case law identifies the judicial independence as the main expression of the rule of law and of effective judicial protection, cooperation mechanisms based on mutual trust must be tested against this requirement and the existence of effective judicial remedies under Article 19 of the treaty. So the lack of real guarantees of judicial independence in a new member state, according to EU law parameters, may compromise the presumption of respect for the principle of the rule of law and mark the limit of the absorption capacity. This limit cannot regress compared to the commitments made at the time of accession, but must evolve together with the notion of the rule of law in the EU law. The accession of Ukraine takes place in a complex context, so marked by the difficulties of the Western Balkans, subject to a stricter interpretation of conditionality. So Ukraine and Moldova, by contrast, quickly obtained candidate status with less stringent checks on the rule of law in the pre-accession phase compared to Balkans. And to balance this speed, the possibility has been raised of suspending negotiations or introducing transitional periods and sanction in case of non-compliance with the rule of law. In any case, uh, compliance Compliance with the principle of absorptions referred by the European Council of the 23 and 24 of June 2022 remains binding. So the progress of candidates depends on fulfilling the Copenhagen criteria and on the EU's capacity to absorb new members. Absorption, understood as a principle, thus becomes the insurmountable limit in negotiations. So, without full compliance with the rule of law, the signing of the accession treaty is not guaranteed. And an important role in these oversights belongs to the European Parliament. Its rules of procedure, and I mean Article 87, paragraph 5, require its approval even before the signing of the accession agreement, thereby ensuring constant monitoring during the negotiations. And in addition, through the competent committee, Parliament can request regular information from the Commission and the Council and issue recommendation to be taken into account before the conclusion of the treaty, strengthening oversight of the candidate country compliance with the rule of law. So the attribution to the European Parliament of a veto power, even before the signing of the agreement, makes it possible to verify compliance with its recommendation during the negotiations, strengthening their effectiveness. In this way, Parliament can monitor compliance with the values of Article 2 and rule of law by Ukraine even after its candidacy has been positively assessed, correcting delays or shortcomings with target recommendations, and ultimately denying approval of the accession treaty. So, applying mm, overly strict conditionality to Ukraine would mean failing to recognize the context in which its accession request was made, that was Russia's war of aggression. And the granting of candidate status is part of the EU's broader strategy of response to the invasion. So the granting of candidate status is mm, part of the strategy alongside other extraordinary measures, such as the activation of Directive 55 of the 2001 on temporary protection, motivated precisely by the exceptional nature of the situation and by Russia's violation of international law. So um, ultimately, absorption capacity and the Copenhagen criteria must be read through the prism of the values enshrined in Article 2 of the treaty, so as to guarantee a balance between the need to continue enlargement and the need to preserve within the EU the near absolute presumption that member states respect the principle of the rule of law, which is the foundation of the mutual trust. I hope that everything was clear. I excuse for my voice and see you. I thank you for your kind attention and see you very soon.